All right, well, I'm going to get started and we'll see who else joins us, if anybody. Hello, everybody. My name is Dan Rodriguez. I'm Chief Deputy Prosecutor for Bonner County, and I'm here to introduce some members of my team that are instrumental in our fight against offenses against children and in our fight to protect victims as much as possible. They're going to be your presenters for the next segment. First of all, we have Nick Lepire, one of our prosecutors, also known as Nick the Hammer, for his dogged pursuit of justice in all of these cases and in all of his cases, but particularly in the sex offense cases. Nick is part of our sex offense prosecution team. He handles all of the teenage sex victims, a very difficult group to deal with, as I think everyone here knows, and he is exceptional at it. He communicates with these victims in a way that that surprises even me. And I've been doing this for a little over a quarter of a century, but he has a way with getting people to open up to him and then open up to the court in a very effective manner. He's an excellent trial attorney. He has done domestic violence cases, every other kind of felony and misdemeanor case. And he is an absolute asset to our department. And without him, I don't know that we would have the success rate that we have in those victim cases. He's also a dad with a couple of beautiful kids, and by all accounts, an excellent husband. Mediocre football player, does okay on his fantasy football league. You know, we don't want to get too bad, but the purveyor of fine craft beers too. So an excellent man to know. On the other side of the table is Valerie Fenton. She's our senior deputy prosecutor. She's also on the sex offense prosecution team, and she has the unenviable task of handling the small children, as young as they get, that are old enough to tell us what's going on in their lives. It's pretty amazing to watch her work with these children. She does an absolutely fantastic job of putting them at ease, putting their parents at ease, and letting everybody in the process know how much we're fighting to get justice for them. She's been doing this since before law school. She worked at the Vanessa Behan Crisis Nursery, which got her into child advocacy and actually led her to go to law school. She went to Gonzaga, and at Gonzaga was part of the Child Advocacy Association and on law review. Kudos for that. And the Public Interest Law Project. She's been with us for a little over 12 years. And in that time, not only has she handled all of the small child sex cases, she has also handled almost the entire Child Protective Act caseload. She has been at that for many, many years. She is a tireless advocate for children and a benefit to our department and a benefit to the children in Bonner County. In the middle of the table is Peggy Sherman. She is the director of the Lilybrook Family Justice Center. She has been in our office since 2005 and has been working with victims since the beginning. She works with not just child victims, she works with all of our victims, crimes of violence, property crimes, families in homicide cases, and she handles all of those with an amazing talent for dealing with people, for understanding what they need and meeting those needs on every level. She's not alone in her battle, though, with these victims. She has her partner by her side, Ken, our black lab, who is the official poster child for support animals in court. It was Ken's law passed in 2015 that allowed support animals into the courtroom for our child and vulnerable victims and witnesses to testify. And Peggy was instrumental in getting that legislation passed. A couple of years after that, she started our Family Justice Center, the Lilybrook Family Justice Center, named for two of our earliest victims, Lily and Brooke, and has taken on more and more responsibility with every passing year since she started it. She's the director, she's the lead forensic investigator. She runs our multidisciplinary team, or MDT team, which is where we meet with detectives and social workers and psychiatrists and psychologists and the health and welfare department and everybody involved with handling all of these cases. And she somehow herds all those cats into a very effective team. It's a very impressive team we have here in Bonner County, and I think you're going to learn a lot from this presentation. Thank you.
Thank you very much, Mr. Rodriguez. That wonderful introduction. We certainly appreciate it. We're going to get started. If you give me 1 second, I will screen share our presentation for everybody so you can see, follow along with what we're talking about. Okay, so as Ms. Rodriguez mentioned, so I'm Nick. We have Peggy and Valerie here with us as well. What we're going to talk to everybody about today is forensic interviews in court. So specifically, what we do, how we get and work together, how we get our forensic interviewers actually testifying in court, and how they help us present cases and not only build up our own side of the cases, but then also try to attack and tear down the defense side of the cases. We'll kind of go through the presentation, talk about what we do, what kind of presentation and preparation we do, and then also how closely we try to work together as so without any further ado, we'll get started and we'll let Peggy start to take it away.
All right, thanks, Nick. So before we really get rolling, I just wanted to point out that we want this to be a really interactive session for you. So feel free to type questions in the chat, stop us, turn your mic on, and interact with us. We want to be able to answer all your questions, or we're here if you want to pick our brains. So please take advantage of that. Allison Fox is here to moderate. She'll be watching those questions for us. So, so we're going to get started. We're going to go over in this presentation kind of the history and procedures of forensic interviews and the Child Advocacy Center model, MDT model. And then I'm a forensic interviewer, and so this is really geared towards getting that forensic interviewer in court. So we're going to go over your interviewer records, what to do when you get served with a subpoena. We're going to talk about how we collaborate here as a team. Obviously, I'm surrounded by 2 prosecutors, so we have a great system down. So we want to share that with you and what that looks like. And then we're really going to dive into defense expert witnesses. So those the defense experts that come in and try to attack everything that we're doing, and how we can really counter that and address those issues that they bring up. We'll talk about defense tactics, the things that they bring up, and then we'll just go over some court lingo, kind of the basics of just being in court, what to know when you get up there. Getting started with the history and procedure, you should always know the history of your organization, who you work for. So some forensic interviewers are law enforcement officers. So just know how you got into forensic interviewing and what the history is of your organization. Those forensic interviewers that are part of child advocacy centers, know the history of your center. When did it start? Who started it? What kind of history can you give the jury about what it is that you do and where you work to help them understand? Because they don't know. They don't understand what, when you go out and you say a child advocacy center, people have no idea what you're talking about. So it's really our job to educate the jury on what a CAC is. And then it's important to know and understand what your procedures are within that organization, how do people request forensic interviews, who do you take requests from? For us, it's law enforcement and child protection. It's probably pretty standard, but understanding that those are the ways that interviews come into us. We just don't take people off of the street. We are not the ones picking the kids for interviews, that those come to us through a system, and being able to explain to the jury what that system is. So just understanding that before you get up on the stand and be prepared to answer those questions. And then part of a CAC, part of this whole movement is the multidisciplinary team. And you're going to want to talk about your team, how often you guys meet, who participates on that team. In our MDT, we have the prosecutor's office, and then we have law enforcement in our area, in our jurisdiction. And then we also have health and welfare, the school district, juvenile probation,
adult misdemeanor probation.
Adult misdemeanor probation. We have mental health counselors, and our local community health center is involved in that. And really just how that works as a team to be addressing those children's needs, and the things that we talk about in that multidisciplinary team. Did you want to?
I do. As Peggy was mentioning, we do have an MDT here in Bonner County, and we meet twice a month. And our agenda right now is approximately 8 pages of cases that we staff each time we get together as that team. And not only are we required by statute to have an MDT for each county, but really it's been a huge benefit to collaborate with everybody, to come to the table and really use everyone's expertise to make these cases better. So not only are we staffing, cases that are still getting scheduled for forensic interviews, but we're staffing them as we're preparing to charge them, and then also as they're going through the court system themselves. So we really have that opportunity to talk about what pretrial motions we might be seeing, what defenses might be coming, if there's been an expert witness disclosed. We can talk about how a child's doing in school, which sometimes is really an indicator of something going on in their home or family life. We also collaborate with health and welfare to find out, really how that family unit is working. And all of that information really leads to better prosecution for us. But more than that, it really leads to better overall safety and a better final outcome for those children. So we think it's really important to participate in an MDT, and we're happy to talk to you anytime about how ours is running and what the benefits are.
So on these kinds of cases, when you're dealing with child abuse cases, child sexual abuse, it is just really important that you have joint collaboration with all of the entities that are involved in that child's life and that are involved in investigating that case. You really want to get to the table and involve everybody in that process. So that's your forensic interviewer, that's your CAC, that's your prosecutors, that's health and welfare, your detectives. So if you have an MDT in your county, it's just really important that you really participate in that and take advantage of that. I know from our perspective, since we started doing it this way, our cases, the quality of them has just increased exponentially. And we're just doing better by the kids and making sure that we are really focusing on what their needs are and how well they're doing and what we can do as a team to help them through this process. And so we start with the forensic interview. And so for those of you who don't know, a forensic interview is a structured conversation with the child. It's intended to elicit detailed information about a possible event that the child may have experienced or witnessed. And so those interviews take place in a CAC by a trained forensic interviewer. And when we're doing that, our team is observing from another room as that interview is happening. So we have detectives in there. We make sure that we try to have a prosecutor, at least one prosecutor. Sometimes we get
two.
more when we're lucky. And detectives, health and welfare, prosecutors, sometimes advocates, to watch that interview while it's happening, so that they can collaborate while the interviewer is doing the interview itself. So, and these guys can talk about what that collaboration looks like when I'm doing the interview.
Sure. So generally when we're set up to watch the interview, we're listening very carefully to what the child is saying and also looking at their body language as they're saying it. just so we can absorb fully the disclosures that they may be making during that time period. But we also are having a lot of side conversations in the room at the same time. So that side conversation can be, taking note of where we might need clarification when we're looking at, there might be a couple of counts we're seeing, we need clarification on the location. So we're looking at jurisdiction issues. We might be clarifying, other details just to look at what charge it could be. What body part are they touching, over or under the clothing, just to get clarification so that we can really review the statutes. So oftentimes we're looking at the codes while we're in there. We're talking to our law enforcement officers. If there's health and welfare present, we might be staffing whether or not we're going to shelter that child. That might be, a conversation we're having with the officer who's present. We even had one time where our detective who was in the room kind of disappeared mid-conversation and mid-forensic interview, and he actually had just walked out and decided he was going to go make that arrest right now. So there's a lot of moving pieces during the forensic interview itself. But I will say that from a prosecution standpoint, to be able to see the interview as it's happening, and then when Peggy takes a break during the interview, to be able to suggest those points of clarification, that's really crucial. So if you have an opportunity to watch forensic interviews as a prosecutor, I would really encourage you to do so. We have had weeks where we've had forensic interviews 4 of the 5 days, sometimes even 5, I think. And Nick and I both try to be here as much as possible. And I think it has made a huge difference in just being invested in the case from the get-go. We also have an opportunity to meet the child that day and to start establishing that relationship. And that really carries through to the end of the case. And I think improves the process for everyone involved as a whole.
Yeah, I think it's really, really invaluable, really. And I think we consider ourselves really lucky, pretty fortunate, pretty spoiled to be able to have Lilybrook here, where it's a one-stop shop. We watch the forensic interview, we meet with the victim, we meet with the detective who's going to be on the case. Peggy is obviously going to be our forensic interviewer. So everybody who's going to be involved in that case at trial has met and right away. And so then we were able to come up with a plan of action, whether it's going to be, we're going to go to a search warrant, arrest warrant, maybe a probable cause arrest, maybe we're going to wait on charges, you name it. But we can discuss all those things and establishing rapport with our victims, but then also earning some credibility, I think, with them in terms of maybe it's not what they want to hear about what's going to happen in the process, but just knowing what the process is going to be and seeing a familiar face every time they come back around for another meeting or getting ready for court or what have you. So it's really, I think, pretty special what we have going on here.
Yeah, absolutely. So as an interviewer, when you get called to court, you should always know your protocol and the history of your protocol and what is that protocol, and be able to explain it to a jury. Who developed it? What's the research based on? And be able to identify all stages of your interview. So for the forensic interviewers that are listening, you know that you go through several stages during that interview. And it's important to point out to the jury what you're doing there. And you're starting out with just covering the ground rules, and then you're moving into some rapport building, and then you're doing some practicing, and then you're transitioning to the disclosure phase. And being able to talk about all those different phases so that if that forensic interview does get played in court, the jury can follow along with what you've already set up and told them about how that interview works, so they can understand why you're asking all these questions that really aren't relevant to the case. And then they can almost follow you on how you're asking questions and why you're asking things. So it's really important to educate the jury what you're doing during an interview. So to be able to do that, you really just need to know and understand your protocol, how it was formed, what the research is, and why you're doing what you're doing. So. Also, when you're up there talking about interviews, as an interviewer, you should also explain to the judge and jury what peer review is, how often you're required to do it, why it's necessary, And when you're speaking to the jury about this kind of stuff, make sure you're making eye contact with them. You're really just presenting to, you're having a conversation with that jury on what it is that you do and how you are staying relevant and up to date in what you're doing. So I've been asked on the stand, just does anyone review your interviews? And, being able to answer, yes, I do peer review this many times. It's required by National Children's Alliance, the standards, and really just going into what that is, really just to educate the jury on what it is that you're doing, but also, in my experience, the defense experts, which we'll get to later, don't really understand this part. And so this is where you tend to lose the defense and their experts, unless they're an actual forensic interviewer. They don't typically know these things. This is a great point too, when you're talking about a forensic interviewer, the procedure and what your training looks like, what your requirements are. This is a great time to talk about NCA standards. And if you don't know what that is, that's National Children's Alliance. And they are the governing body, the standard. They create the national standards and best practices for children's advocacy centers across the United States. And so if you're following those procedures, then you're following best practice, you're following national standards, and that really gives you the credibility on the stand that you're the one following these procedures, that everyone else is as well. And then again, in my experience with defense attorneys and defense experts, they have no idea what NCA is. They have no idea what these standards are. And so this really just starts to build your credibility and make the jury understand that you really know what you're talking about. And this is, you're doing this, you practice this on a daily basis, and this is what your career is all about. Whereas defense experts typically are not forensic interviewers. So you really start to make that divide on who has more knowledge on the topic, which is what you want to be doing. But you also want the jury to understand who you are and what you do. And so your job on the stand is not solely just to talk about the interview that you've done. That's one piece of it, but also you're establishing yourself as the expert on the stand. So the more you know, the better, the more you can explain, the better. So if you're talking about national standards, if you're talking about statewide standards, if you're talking about peer review standards, if you're talking about your protocol and all the pieces and parts, those are the things that are going to set you apart as the expert in what you're doing, and then divide you from that defense expert who doesn't necessarily understand those things. And just keep talking. The more you can explain, the better. My theory when I get up there is I just talk until the defense objects. I try to get in as much information as possible in as little time possible. And the more you start talking, they realize, the defense attorneys start to realize that you really know your stuff. And so this is why, as a forensic interviewer, it's really, really critical that you really prepare for these times that you get to be in court, because you start out this case as the person doing the interview, but you really have the opportunity to really drive it home when you're on the stand. So if you can visualize it as, like a baseball game, you hit the ball and you got on first base, and then, the rest of your team got you around, and now you're on third base and you're ready to run home. If you're prepared, you can walk it home. But if you're not prepared, you're going to be diving in, and it's going to be messy, and it's going to be ugly, and you might not win. So the more you can prepare, the more you're able to just really drive this home, that what you're doing up there is best practice. You follow standards, and you are the expert up there, not the defense expert.
Too many?
You went too many.
Whoops.
I'm going to make one other comment actually while you're fixing the slides. One other thing that is kind of an added bonus from having Peggy testify as far as really teaching our jury about what a family justice center or a CAC does is that those are people who are going to go home after the trial and also talk to families or friends about their experience. And the more information that we've provided to them in that teaching moment, the more that gets out into your community and the more you're going to find that you have support for your family justice centers, for your CACs in general. I think over the 4 years, or 4 years next month, I believe, for our Family Justice Center, we've really seen just an increase in investment from our community partners and also from the public at large, just understanding what it is that we do here and the purpose and, just what we're trying to do to help kids in this community. So really having that teaching opportunity, it spreads because your bailiffs are hearing it, your court staff is hearing it, and also your prospective jurors and then actually your seated panel are hearing this and they are going to talk about it. And to be able to share with them that knowledge base and to show that it really is something that has best practices, that has national standards, those are things that you'll find that will support you moving forward in what your prosecution office is trying to accomplish. So it's even broader than just that trial itself. So take that opportunity when you have it to have your expert on the stand, and until you get objected to, keep talking about it.
Keep on talking.
Keep going.
All right. So as an interviewer, if you get called to the stand, well, if you're doing forensic interviews, first things first, before you ever get called to the stand, you need to put together a CV. If you don't already have one, please start putting one together. This is where you are going to establish yourself as educated and knowledgeable in the field. So every training that you've gone to, everything should be listed out, things that you can back up and prove. So if you went to a training and you did not get a certificate, there's no record of it, don't put it on your CV, because you need to be able to back up with records anything that you have put on that CV. Also, as a forensic interviewer, someone working with victims, you really should be getting as much training as possible. Stuff changes all the time. Victims are complicated to work with, and understanding their dynamics. Training is going to be the one thing that in my opinion, I've been doing this for almost 16 years now, that keeps you going. You stay refreshed. And as far as forensic interviews go, the research and the best practices, they're changing all the time. So you really need to stay up to date. So get your CVs together. The next couple of slides are just an example of what mine looks like. Include any professional organizations that you're involved in. If you're part of, if you volunteer anywhere, if you sit on any boards, anything like that, and anything else that just makes you stand out. I mean, this isn't just, here's what I do and here's what I've been educated on, but here's all this other stuff that I do. I volunteer as a baseball coach, or I volunteer my time at the food bank, or whatever it is that you do. Put that all on your CV, because that's all relevant and that's all very helpful to show you as a person. That's really just the picture. And you'll see later on that your defense experts are providing theirs. And so when you have yours and you can compare yours to theirs, yours is going to look a lot different than what theirs looks like. So the other thing is, when you're preparing to go to court, and I just would recommend knowing it all the time, is know your number. Know how many forensic interviews you've done. So it's a good idea. I always get asked, how many forensic interviews have you done? And I can rattle off a number. And then when the defense expert is asked, when the prosecutor asks the defense expert how many they've done, it's very few, if any.
Yeah.
So that number is really going to stand out as, okay, so this one's the forensic interview. This one doesn't even do forensic interviews. So that's a really important number to know. The other number you should know is that particular interview that you are there in court for. what number is that? So I know my number complete, and then I go back and look at, I keep a record of every forensic interview that I've done, and they're all numbered. So I know this is the 87th interview that I did. And that's really going to show the court and the jury that you know exactly what you're doing, you're prepared, and you keep great records. So. And there's a poll up. So have you ever experienced a defense expert pick apart your CV or your interview? And then this slide is basically just the next 2 or 3 slides is just an example of my CV. It's long. These are, for me, awkward to do because you're used to doing a resume or something and just being short and sweet, but you really, this is your opportunity to brag. Look at everything I've done. Don't hold back. Look at all this training I've attended. Look at all these awards I've gotten. Look at all these organizations I'm involved in. Look at all these boards that I sit on. This is your time to shine. This is where you tell people why you do what you do and why you know your stuff.
And do you think that you write your resume, it gets disclosed, and then do you think it's kind of out of sight, out of mind, so that when you get to trial, you don't remember what's in your resume?
No, this is a living document. So this, just because we put this presentation together a while ago, this has actually been updated since we put these slides together. Anytime I go to training, the first thing I do is I add it to my CV. And so I'm always going back through and reviewing my CV. I'm looking at all the training I've been to. I'm thinking about, okay, the last time I did peer review was this. And really, because they're going to be looking at this. This gets disclosed through discovery. So you need to know what's in your CV and you need to stay up to date and current with this document. So this is something that you need to keep in the back of your mind that, okay, I went to training, I have this certificate, now I need to log it on my CV and just keep that going.
Do you think that defense experts and defense attorneys have read through your interview and are prepared to grill you on what's in there or maybe what's not in there?
In my interview or my CV?
Oh, I'm sorry, in your CV, yeah.
I think absolutely they review it. It's listed every time we get an expert report that they've reviewed my CV. What I've experienced is they typically stay away from it.
I would also anticipate, as we're seeing better funding for some of the defense offices, that their investigator will also be going through and critiquing it. So I can't really reiterate enough to please be accurate. So as Peggy had mentioned before, keep your certificates for the things that you've attended. Make sure that you can back up everything that you've listed, just because we don't want there to be any issue with it, whether it's inadvertent or not. We just want to make sure that your resume is as accurate as possible. I know we had attended a training before where someone had found something that was inaccurate on, I think it was a defense expert CV actually, but that, it blew everything up. And so we just don't want that to ever happen for any of you or for us. So it is really important to keep it up to date, know what's on it, and make sure that you can confirm that you've attended those things by keeping your certificates.
And so mine is up on the screen and you can see I'm listing out everything. It doesn't have everything to do with forensic interviews because I've been doing this for a long time and I started out just doing domestic violence stuff and I've gradually worked my way up, but all of that is relevant. All of that shows that I continuously seek out training, what that looks like, what those topics are, and how often I'm going. So you can just peruse through there and see what I've been doing and just get an idea of the things that you should be including on your CV as well. Lots of dog stuff. Let's see in there. So, and I go all the way back. You'll see that last one on the left-hand column, all the way back to 2005. I started in October 2005, and my first training was in November. And so, really just going back as far as you can to the things that you have certificates for, and that you can back up that you did actually go. The other thing that you're going to want to put on there is any accomplishments. Anytime you've been asked to speak about something, put it on there. You know, this establishes that people want to hear from you, that people want to learn your knowledge. So I've spoken a lot about dogs. Ken seems to be more popular than anything else that
Any of us.
any of us. So, but those things are important because it shows that, you know, just because I'm speaking about dogs, it shows that people are interested in what I have to say. So I also have this knowledge about forensic interviews and running a CAC and things like that. So, and then include your memberships and affiliations on there. So if you have memberships in any professional organizations, you're going to want to list those, past, present. Just include it all, because this is, like I said, this is really your time to shine. This is your time to show, like, here's who I am, and here's why I know what I know, and this is what is going to establish you as the expert on the stand. All right. So we have another poll. Do you meet regularly with your assigned prosecutors to prepare for court? So, so when you get a subpoena, there are some things that you should be doing. In fact, I got one yesterday by the defense.
Yes.
So it does happen. That's not the first time that's happened. In my experience, the defense is real quiet. They won't tell you what they want from you. So when you get a subpoena from the defense, you really need to be going through your interview and trying to figure out, okay, why are they calling me? And just be prepared. And you really need to talk to your prosecutor. If you get subpoenaed by the defense, you need to know that need to let that prosecutor know as soon as possible. You don't want to be the surprise witness on the stand. So this is where things get pretty intense. So once you get your subpoena, you have some work to do. This is my process when I get subpoenaed to talk about an interview in court. And this is not something that I came up with on my own, full disclosure. I learned this at a conference in Dallas, and I used it and implemented it, and it works. So first, you need to confirm who your subpoena is from. It doesn't matter. Ultimately, you treat them the same, but it's going to give you an idea of what kind of questioning you're going to be facing. And then don't underestimate the time it takes to review your interview. Your prosecutor is going to thank you for it. These guys can absolutely back me up on that one.
True.
The first thing you're going to want to do on that subpoena, you're going to have a date and time. You need to make sure that your calendar is clear. If you have any prior engagements, you need to be communicating with whoever sent you your subpoena. And then it's important to meet with the issuer. So if you do get a defense subpoena, you need to reach out to them and say, here's, please contact me. You've sent me a subpoena. I would like to talk to you about this, and see if they will talk to you. If the prosecutor has subpoenaed you, you really need to set up a time to meet with that prosecutor to go over your interview. What you're going to need to do once you get that subpoena, you're going to need to gather any relevant records for that particular case. So if you have intakes, if you, as a forensic interviewer, if you do a report afterwards, you're going to want to have that available. And you're just going to need to make your own court file for that case. So what I do, I just get out a new folder and I put my subpoena in there. I take notes in there on who I'm going to meet with or who I've emailed to request a meeting with. And then anytime we talk, I'm gonna jot notes down of what we talked about. You know, Nick's gonna want me to talk about this, or defense wants me to talk about this. So I know going in exactly what is happening and what is expected of me. And then I have all my records right there to back it up. Important to note though, when you're building a court file, if you're going to take it into court with you, make sure that it is clean. Do not be writing any notes that you're not ready to hand over to a defense attorney, because if you're up there and reading notes and you have something, you know, silly or something written in the side, there's always a possibility that the defense is going to ask, you know, what are you looking at? Can I have a copy of that? And then that you're handing over a copy. So just keep that in mind for anything that you're putting in your court file. You don't really want inappropriate notes or, you know, things going to the jury for review if that happens.
And Val, how often do you think you meet with Peggy before court comes up?
Well, anytime I need her to go.
Right.
I mean, that's really what it is. And it's usually more than once.
Right. Yeah.
You know, I think our process here is we talk almost every day around here. So there's a lot of back and forth, whether it's email, text message, whether we're in and out of Lilybrook. Our office is just 2 buildings away. So there's a lot of, you know, back and forth and exchange. We talk a lot.
Yeah.
And that really is a benefit. You know, I know trials have a lot of surprises. You don't want your own expert to be one of them for you. So,
Right.
you know, having that open communication is really important to having as smooth as possible, you know, the state's case as you can, really.
Would you say that this kind of a caseload is a 9-to-5 caseload?
That's so funny. No, no, it's not. I think that we all get calls 24/7, 7 days a week. And so it really is something between, you know, whether it's scheduling a forensic, whether it needs to be after hours on a weekend, whether we need to have a child come in right away. As Dan had mentioned during our introductions, I also handle child protection cases. So there's a lot of, you know, questions after hours for shelters, especially if there's sexual abuse allegations in the family. So I would say that we get called all the time.
Yeah. And then for my piece, which I'm going to talk about in a second, when I'm reviewing interviews, sometimes I like to do these after hours because it's quiet and the phone's not ringing and I'm not being interrupted. So when you're reviewing your forensic interview, so if you've been subpoenaed to court, you have to review your interview. Now, I don't know about any of the other interviewers. When I'm done with the interview, I want to put it out of my head and move on. So I don't particularly enjoy going back and watching it. I really don't like watching myself. That's just awkward. But we need to do it. And these are the tips that I learned and I have implemented, and I can tell you it works. And I feel way more prepared when I'm going to court when I follow these steps. So when you're reviewing your forensic interview, I recommend watching it 3 times. So the first time you're going to review it, you're going to watch and listen. Each time you're going to be taking notes. And so the things that I'm noting is each phase. Did I go through each phase? And if you're a forensic interviewer and you do peer review, you know there's a peer review form. I get one of those forms out and I just check the box. It's like I'm almost doing a peer review of myself. And then I'm noting anything that really stands out, any major mistakes. As an interviewer, you know, there's always those moments you're like, why did I say that? What was I thinking? Why did that come out of my mouth? It happens. But those are things that you're going to want to note. And then you're going to want to let your attorney know, hey, you know, at this point I said this, probably looking back would have worded it differently, but it is what it is. And here's how I'm prepared to talk about that if it gets brought up. So those are the things you need to be jotting down. Anytime a child corrects you, this is a big one because defense experts always pick apart, well, you told them to say that, or you suggested, or you are manipulating them to say things like that. So if you can note, this child corrected me 6 times in an interview, that just goes to show that that child really isn't being suggested, or you're not suggesting things to that child. They're comfortable enough with you that they're correcting you. So those are really good things to point out, because when the defense starts asking you questions, those are the things they're going to go after. So if you can just chirp right back, well, actually, no, they corrected me 6 times during this interview. So that really kind of tends to quiet down a defense attorney. So the first time we're watching and listening, we're just getting a feel for the interview. We're reminding ourselves for everything that was said during that interview, what the allegations were. Okay, I went through every phase. I have a few little mistakes. Here's what how I'm gonna address that on the stand. The second time, you're gonna watch it with the volume off, and you're gonna note body language. You're gonna be watching the child and yourself, and you're gonna note, when did that child, maybe they curled up in a ball, or maybe at some point they were curled up in a ball and they got more comfortable and relaxed. Did they start crying at some point? Did they stop crying? Did they appear nervous? Were they fidgeting with things? You're going to note all of those things, because that's key to, during the disclosure, the child curled up and was not comfortable, and then they got out of the disclosure and then they opened back up, or those are things that the prosecutor can work with. You're also going to watch your own body language. So I have a habit of not tapping my foot, but just shaking my foot all the time. And these are things that interviewers need to work on. I need to work on it. If you are like me and you shake your foot during an interview, that's just my way of tracking and staying in tune with the child. But if I stop during a certain phase, those are things that children pick up on. Those are things that the defense is going to pick up on. And so you need to be able to know that may be something that gets brought up. And really just note for yourself, like, oh, I really need to work on maybe not shaking my foot. And then the third time, you're going to do the same thing, but this time you're just going to listen and not watch. And so you're going to listen for different fluctuations in voice. Do they get louder? Do they get quieter? A lot of kids will get really quiet when they start to disclose. Those are things you're going to note. And then the same thing with yourself. If we try to stay pretty neutral and pretty even, but we're human too. So just noting those things and then putting all of those notes together and going, okay, here is the outcome of this interview. Here's the mistakes. Here's the strengths. Here's the body language. Here's, what the victim did during these phases. That is really going to be able to, when you're on the stand, you know that you have been through this interview so many times, you know it inside, outside, and backwards. And so when the defense surprises you with some sort of question, you just know, because you've already watched it, you've listened to it. And so you really just know what happened, everything that happened in that interview, not just what the allegation was, but everything that happened in that interview.
I think it's also important as a prosecutor to watch the forensic interview multiple times. It's a huge benefit for us to have, that live introduction to the case itself, where we're watching it then. But when it comes to preparing for trial, we're also going to watch it at least probably twice before we ever put that child on the stand. And it's similar to what Peggy does for preparation. The first time we're really watching to hear what that child is saying, how they're saying it, their body language. But I know for me, having the littler kids, when I'm looking at putting a 5 or 6 year old on the stand, it's also a huge benefit to me to watch that interview and take note of what the question was that elicited the response that is a disclosure. That question format, as long as it's something that's not going to be objected to by a defense attorney, it's a question that that child has heard before and that they understood the question enough to give a specific answer. So there are times when I've actually mirrored identically the questions that Peggy was asking a child in a grand jury or a jury format in order to help that child tell in a courtroom what happened. So I think there are huge benefits for us watching it, not just hearing what the disclosure is and what the child had to say, but also to help you prepare as an attorney to help that child tell that story again by using those same questions. So for the attorneys out there, I would really encourage when you are preparing for trial or to put a child on a stand in any proceeding that you watch it at least twice.
Yeah, absolutely. And I think it really is, if for whatever reason you're in court or other obligations, if I'm not able to watch the forensic interview live, it's for me so much harder to grasp that case watching the interview back after it's recorded. When you're able to see it live, it sticks with you, at least for me, so much more. I don't really know why, but it does. You know that case so much better if you've watched it live. Okay, so we're going to transition to the defense experts. So we just spent our time talking about building up our experts, our forensic interviewers. What happens when you get a defense expert? As we kind of talked about, we're a team, and you can use your forensic interviewer as your expert, not only to build your case, but then also go on the offensive and attack the defense case. So these next few slides, we're going to dive into a case study, a case example. And along the way, if you guys have any questions, please feel free to chat up a question, and we'll address it as we go. So we're going to talk about real world examples. You're going to see an actual defense report, an actual defense interview, or not interview, a resume, and sort of to protect the innocent or what have you. I've redacted a lot of it, so you're not going to necessarily see their name, but the important part will be there, and we're going to kind of dive in and go into how we tear down a defense expert using our experts, using our forensic interviewers. So this particular case that's coming up is actually a case that we had gone to trial on twice. The first time at jury trial was a hung jury. It was 10-2 guilty. So there's 2 people that were voting not guilty, the rest were voting guilty, and the 10 that were saying guilty were very adamant. They were absolutely upset at the other 2 were saying not guilty, and those 2 had some really quirky reasons why they were saying not guilty. But as I spoke to those jurors and gained an understanding of what their thought process was, I specifically asked them, what do they think about the defense expert in that case? And they told me that not one of the jurors gave the defense expert any weight whatsoever. So the reasons for those 2 people to say not guilty had absolutely nothing to do with the defense expert. So the defense, they didn't sway anybody at all with their person. And we'll kind of go into how we made that happen, how we're able to tear that apart at trial. And I'll tell you, I had to lean on Peggy quite a bit. I couldn't have done it without her help. And when I first got the report and the resume, first thing I did is I forwarded it right to Peggy. Can you help me? Where is this person wrong? Because I think the defense, they're going to have a hard time if they want to try to attack the child at trial, right? Because it's either going to be a 6-year-old, 8-year-old, very sympathetic child, or a teenager, and I don't think it's going to play very well for them in front of the jury if they want to go after the child. So what are they going to do? They're going to go after the process. They're going to go after what the detectives did, what our forensic interview did. So we know that what they're saying isn't going to hold up, right? It's not true, because we know we're on the side of truth. We have a victim. We sat through the forensic interview. We believe our victim. So how do we go about showing what the defense expert is saying is not true? So that's kind of what these next slides will be about. And I think if I would say kind of in one word what it is, it comes down to preparation, right? So, and Peggy's talked in the last number of slides, how many times has she mentioned these ideas about reviewing, preparing, knowing your numbers, and that preparation is key. I know that Mr. Rodriguez made fun of me earlier about my football abilities, but there's one person who can play football really well, and that was Peyton Manning. And he said that when he got to game day, he was not nervous at all. He was not scared at all, because he knew he was the most prepared person on that field. When you prepare enough, it takes away the fear. So if you can, so I guess that's what I think the biggest step going forward is the preparation. And so I guess let's get into it on how we tear apart the defense expert. So this is what we received in that case. So obviously I've blacked out our victim names, the case number, defense expert's name and their contact information. That's not important for purposes of today, but what is important is when you get a report like this, what are they doing? They're telling you exactly what they've reviewed. And so we talked about our forensic interview experts. Well, what's one of the things that they're looking at? I'm going to move my cursor over, hoping you can see. They're looking at Peggy's CV. So they're specifically looking at her resume, and that person's going to try to come in and attack our process. So if they're looking at our expert's resume, let's return the favor, right? Let's let our people look at their stuff. And so that's exactly what we did. We took the report and their resume, and I chatted with Peggy about it, I don't know how many times, about how do we go into court and how do we tear this apart. This is their last page of their actual report. They came up with these 12 things that they thought were what they call critical issues, or what they're calling the problems that they're perceiving with the case. I think it's noteworthy that in all of these 12 things, all the 12 things that they said were issues in the case, not one of them was Peggy's forensic interview. That wasn't an issue for them. The closest they came to it was number one. They said that the reliability of this one victim, I think it's noteworthy that in this case, there were two victims. So they're not mentioning the other victim. They're only saying, well, one of the victims' reliability is questionable because of their age, that they don't know the difference between the truth and a lie, fantasy and reality, and that they might not remember what happened after the forensic interview. Well, what does that say? She's not saying at all that they had a problem with the forensic interview itself. This person is not coming into court and saying, well, we don't know based on the forensic interview that they were telling the truth, or that they're only talking about true things. Right? So if you know your process and your procedure and you trust that, then you know that you're doing things the right way. So all the avenues of attack, nothing in here had to do with anything that Peggy did or the forensic interview did. They talked a lot about what they thought the detective might do. They talked a lot about child protection history and what the parents might have done, but they didn't attack the child specifically, and they did not attack our forensic interview process. So when we look at how we actually go in and start attacking, so on the very first page, the defense expert is going to identify themselves. So this person's going to be coming into court and trying to criticize a forensic interview. Well, who is this person? What do they do? What's their title? This person had the word forensic in their title, but that's about it. That's the only thing that translates, right? They're a clinical forensic psychologist. Well, now we know right away that we're talking about apples and oranges. This person is not a forensic interviewer, but yet they're going to come into court and try to attack a forensic interview. So you compare the defense expert with your own experts, and you can look critically at their title and try to right away identify, are they really even qualified to try to come into court and say whatever it is that they're going to try to say. And we touched on this earlier. So they're identifying what sources of information that they're looking at. And one of them is they're looking at Peggy's CV. And we talked about that a little bit earlier. I asked Peggy, when you write your CV, do you just forget about it and move on? No, I mean, they're going to be talking about that in court. Mm-hmm. So we should be prepared to talk about that in court.
Absolutely. And then Nick, you talked about it a little bit, but you're talking about the report, giving me the report. And the whole reason behind that is because I have all this knowledge about how to be a forensic interviewer and what it takes. The prosecutors don't necessarily speak that same language. They're not up to speed with everything that we're doing, or what NCA stands for, or what the standards are for peer review. And things like that. So they're really relying on you, the forensic interviewer, to tell them those things and to pick that stuff out of that defense's CV, so that they can attack the defense expert on the stand, just like the defense plans to attack us. So.
Yeah, we just, and again, I wouldn't have known to clue into all those things had I not talked to Peggy about, so, and you can see even here on this phase, we had the report title where this person's calling themselves a clinical and forensic psychologist. We get to the CV and all of a sudden they're just calling themselves a clinical psychologist. So you can pick up on little things like that. Like Peggy's mentioned, know your number. So where in this resume are they listing out the number of forensic interviews they've done, or the number of hours of training on forensic interviews have they done? As you'll see in the next couple of slides, there aren't any. So this person did not do any of that kind of work. So you can compare that with the kind of work that we do on our end. So as a highlight on I picked out the closest things that this defense expert did to what we do. And you can see they're not even close, right? They're not forensic interviews. They're not trained. They're not even in the state of Idaho. They're like 20 years ago. So this really just comes down to apples and oranges. So when we meet and we prepare and we think about challenging the defense expert, knowing this kind of stuff and comparing it with what we know, that helps you go into court and tear down the defense expert.
We're going to switch gears a little bit and talk about some of the specific tactics to watch out for when you are being cross-examined by a defense attorney. And one of the first ones that we see quite a bit of is just the way that they're going to phrase questions that they're asking you. A lot of times they're going to be overbroad or speculative because they want the jury to speculate that there's some other explanation out there for what's happened. So they're going to try to use you to create this alternative, answer besides just this actually happened and we need to convict. So a lot of times you might see, isn't it possible that questions? And you can always say, well, it might have been possible, but in this case, this is what actually happened. So, first, you don't have to accept the premise of the question, but you also can tailor your answer to draw it back to what specifically did happen in this case. But listen carefully to the form of the question from a defense attorney on cross-examination, and then just stick to what actually happened and what you know. Whether it is a child witness, whether it's one of our law enforcement officers or Peggy, our expectation is always just that you tell the truth and that you share the knowledge that you have in the courtroom. So you don't need to speculate, you just talk about what you know. So don't fall for that trap of, well, just about anything is possible, and then you're going to have this jury out there that's like, anything is possible. So maybe this didn't happen. Stick to what you're there to talk about and don't go off into the weeds or follow the defense attorney there, because it is a favorite tactic of theirs. One of the questions I've seen Peggy handle on cross-examination is she was asked why a child gave a different answer in the courtroom than what they had answered a question to in the forensic interview. And she actually handled it really well. And I don't know if you remember how you answered it or not. Do you want to answer it?
When I was asked that question, the defense attorney actually posed it to me in the following way. He said, would it surprise you to know that she gave me a different answer to that question than what she gave you? And I just said, no, absolutely not. And then he said, well, why not? And I said, because I don't know how you ask the question, and this is not a setting that is friendly to children. Yeah. So
it goes back to, we're all talking to children in a different way. So if it is a different form of a question, that might lead to a different answer. The sterile environment of a courtroom is not friendly for our kids. It's a lot different than, our Family Justice Center is a house. And obviously we have Ken, our courthouse facility dog, and that's a lot friendlier environment for these kids to talk about what's happened to them. And it is important to remember that what they're talking about is something that is emotional, that might be shameful to them, that we're asking them to talk about personal things, their body, in front of strangers. So it shouldn't surprise anybody that you're not going to get this identical answer, and it could be a year later,
right?
A year in between their forensic interview and their time in court. Something else that I think is important to remember is that children don't necessarily disclose if they don't feel safe. So I had a child protection case where we had some disclosures, and ultimately there were 2 criminal cases that came out of that. And we also had a child protection case that led to termination. And we received disclosures multiple times, and they were additions to the information as the kids felt safe. And finally, after we did the termination of parental rights and these kids knew that they weren't ever going to have to go home, was when I think we finally got most of the story. I don't know that I would actually say that we ever got all of it, but I think it's important to note that there's these other factors at play for when you're going to get information and how much information you're going to get. Peggy's also had challenges to her training and experience and just questions about her CV. So that just goes back to, staying up to date on it and also knowing everything that's on it. Hopefully you won't have a defense attorney who wants you to explain, what did you learn at each one of these trainings that you went to? But if you do, it's nice to have a short answer. This training focused on this issue, and this is the one thing that I took from it. If you have time, go ahead and think about that as you're filling in your CV and updating it. But it is important that you can address each of the items that are on it. She also has handled challenges to the forensic interview protocol. As you know, there is more than one protocol nationwide that is in use. So Peggy has answered questions about which model our Family Justice Center, CAC, is currently using, and she's able to speak to that. Why are we currently using that model? What other models are in use? And so it's just a chance for her to shine when a defense attorney asks that question.
And interestingly enough, this has happened with a few different defense experts, is their little knowledge on forensic interviews is always based on NICHD. And so, while NICHD is one model and it is considered the gold star, there are several other models out there, and NICHD has been updated to Utah CJC, which is what we use. But when the defense experts start talking on the stand, they're talking specifically about NICHD, and I think every single one of them has been dead set on that's the only protocol out there. And so being able to come in and say, no, there's actually this whole list of other models that you can use as long as it's approved through NCA and it's on their list of approved protocols, that really kind of shoots them out of the water as someone who really has no idea what they're talking about, and the information that they have is outdated.
Yeah, and on a couple of, on a couple of fronts too, because not only can Peggy talk about that, your forensic interview talk about what they use, but then they can school the prosecutors up, school us up. I had no idea all the different models and acronyms that are being used. So the jury also wouldn't, right? So, but then I can go on the offensive with cross-examination and point out the differences. And then Peggy can also talk about that independently of that. So then the jury's getting to hear twice, both on cross-examination, the different models and what's used and what's not used, what's outdated, but then also from direct testimony from Peggy too.
And I think it's always really interesting when they are adamant about this one model, and then Peggy's able to say, well, actually, we refer to that as the Utah CJC now and have for several years. And here's why, because it just points out how old and dated their information is as an expert, and how they are not choosing to stay updated in this field that they've been brought in to be the expert to testify to. So it really just gives Peggy more credibility and shows that they really aren't an expert the way that they've been held out to be. So it's entertaining when it happens.
Yeah, and I think just kind of as a side note, with a funny thing that happened with this particular expert, Nick asked how many interviews she had actually done. And
It was funny.
there for the answer, but I heard about it, so you want to talk about that.
Yeah, she, well, she didn't know her number, so that was a big thing, and then tried to make up, I use that word make up, but she had tried to say, well, on Monday I did one, Monday before trial or something like that. So really didn't know her number, so wasn't able to rattle that off. If someone asks you an open-ended question, well, how many have you done? You should be able to say, I've done this many. And, so not only did she not know her number, used kind of what I think is kind of an arbitrary date of like, well, Monday I did one. But it would have been in a totally different state, using a totally different model, not up to Idaho's. And, how does that qualify that person to critique our forensic interview of these victims in this case?
And then it just shows that when you can catch them off guard like that, and she doesn't have an answer to that, she doesn't know her number, she doesn't really even know if she's done a forensic interview,
Right.
or when it was, or anything like that, it catches them off guard, and you get these really unplanned answers, and then they get a little squirrely on the stand, whereas then you've been asked that question and you know exactly what your number is. It just goes to show that you're prepared and they're not.
Right.
What I remember about her answer on that, how she was handling it, is she kept saying, but I trained under, the leading scholar in this area. Okay, you kept going back though, like how many interviews have you done and when did you do them? And it was just really interesting. She just kept trying to redirect to this other answer, and she named this person that we were like, well, we don't know who that is, and that's not impressive to us. So it was interesting to watch Nick do his cross-exam on that and really point out her lack of expertise.
But those are the things that, working together, we can educate our prosecutors on and give them these pointers that, hey, ask them this and see what they say.
Yeah.
Because it's not listed anywhere on that CB. So those are the things that your prosecutors aren't necessarily going to know to ask if we don't talk to them and communicate with them and work together to really go after that expert.
Yep, absolutely.
Right. So overall, really it's crucial to be as prepared as possible. And the other thing I want you to remember if you are subpoenaed to testify is to maintain your composure and be polite. You are going to be cross-examined by a defense attorney. They are going to try to trip you up or to get you to have an emotional response or show your frustration. And when we train our officers when they're going to testify, we tell them, don't make your response the story. You need to maintain your composure at all times and just let the defense attorney get flustered. Let them be the one who's showing that they're not getting what they wanted out of you, and just keep going back to, this is your knowledge base, this is your opinion, and just share the information that you have. Do not lose your temper. I know that's really easy for us to say because we watch it, but really you don't want to lose your cool, because then that's what's going to basically take the jury's attention, and it's going to be, well, why is that flustering you? And is there something we should know about that? What are we focusing on? Or they're going to focus on, your response instead of the content of what you're actually saying. And we want them to hear what you have to say as the expert. So also, as we said before, communicate with your prosecutor in advance. Nick and I try to make ourselves available as much as possible to Peggy and to our team overall. We really see this as a team effort to be successful on these, and that communication and accessibility is really crucial to moving these cases forward. So know your case. Peggy mentioned earlier when she watches her forensic interviews to prepare for testifying that she makes notes of any errors she might have made, and it might just be a question that she should have or later realize she could have asked a different way. We do want you to take note of that, because if it is something that's going to be critiqued by the defense expert, we want to get out in front of that. We want to have it be something that we're going to address, so it shows that we're not hiding anything. And Peggy or you as the expert can explain, this is how I asked it. Watching it back, I think I could have asked it this other way. Why do you think that would have been better? What do your protocols say for how you could have asked it? And then you're getting in front of it, so it almost becomes this non-issue, and you gain credibility by acknowledging that there's no such thing as a perfect interview. Sorry, but there's not.
There's not.
There's not.
Not.
We're dealing with kids from trauma backgrounds and just emotional disclosures to start with. And so they're sometimes all over the place. So also, when you're being asked a question, answer the question asked. You don't need to elaborate the way you do when we are asking you a question. Just stick to the actual question the defense attorney is asking you. Make them do the work. You don't need to offer up more than what they're asking you to answer. Also, watch your use of acronyms. Utah CJC was one of them. We want to make sure that our jury understands what it is you're talking about. So please use the full name. I know that sometimes that becomes a mouthful, but it really does matter overall in making sure that everyone understands what we're talking about. And then finally, when you are doing your own sort of peer review, as Peggy mentioned, using that check sheet to look at your forensic interview, just take note of any areas where you think you might get attacked by the defense, and then talk to your prosecutor about it, because certainly we can try to troubleshoot ways to address it ahead of time to make sure that that doesn't become an issue at trial.
Yeah, so I think we're crawling up to the or we have gone over.
Are we over?
Yep, I think so. So if you guys have any questions, reach out to us, or if you want to troubleshoot something, let us know. We're always happy to help.
We do want to say, you know, thank you for joining us today. We're obviously, all three of us are very passionate about this caseload, and we realize that it does carry a weight to it. And we really appreciate all of you who are invested in this and who have really just believed these kids and who want to fight for them in court with us. So thank you so much for what you do, and we really appreciate the opportunity to be here with you today.
And yes, we can absolutely share the slides. That was a question in the chat.
Yes.
We can definitely get those to ICDVBA to share, or you can email us directly, and we can share that with you. I'm more than happy to.
We're happy to talk to you anytime.
So
These
Thank
are difficult
you.
cases, and yep, keep up the good fight. Thank you.
Thank you.
thank you.